Welcome. This is our last video in a series of videos reviewing personal jurisdiction, what we call here at St. Thomas Law, PJ Big Picture Day. And in this last video, what I'd like to discuss is specific in personam jurisdiction under the International Shoe Test under current case law. Now, as I've said in several other parts of the video, we analyze specific in personam jurisdiction using a three-part test. The first part is showing purposeful availment. The second part is that the contacts with the state gave rise to the claim. And the third part is to address the reasonableness factors. Now keep in mind what specific jurisdiction is. Specific jurisdiction is when there is a sufficient connection between the in-state contacts and the claim. As International Shoe and its progeny tell us, the contacts give rise to the claim. Okay? Also keep in mind that specific jurisdiction does not require a single contact. It does not require systematic and continuous contacts. There can be cases that fall along the entire spectrum. Generally speaking, if there's only one or isolated contacts, maybe there's specific jurisdiction if they give rise to the claim. If there's systematic and continuous contacts, then it's much more likely that there's going to be personal jurisdiction. So specific doesn't mean single, isolated. Specific doesn't mean systematic and continuous. What it means is there's got to be contacts, right, that gave rise to the claim. Well, I'll give further explanation as we go through the steps. All right, the first step in specific jurisdiction analysis. Minimum contact showing the defendant has purposely availed itself of the privileges and benefits of the laws of the forum state. In other words, you need what worldwide and before it Nathenson calls purposeful availment. Purposeful availment means the defendant itself has reached out to the state. It has made contacts itself. It hasn't been dragged into the state, but rather the defendant has gone to the state or reached out to the state or made connections with the state that are made by the defendant itself. Okay? And think of it also as a quid pro quo. By reaching out to the state, say by doing business in the state, or by traveling to the state, or living in the state, the defendant has intentionally made itself have access to the benefits of that state. It can use the courts of that state. If the defendant is injured, the defendant will be protected by the hospitals in that state. If there's a crime, the defendant can be protected by the police of that state. If the out-of-state defendant enters into a contract with somebody in the state, say I'm from Florida and I enter into a contract with somebody from Alaska and the Alaskan breaches, well, I can go to Alaskan courts and use the Alaskan courts to sue the Alaskan defendant for breach of contract, right? And so on. I can purposefully avail myself of the benefits of the state, okay? When you reach out to a state, you get benefits from that state. And when you get benefits, there may be a price to pay. In other words, quid pro quo. Benefits, obligations. That's how International Shoe puts it. When you have benefits, obligations can arise from those benefits. And that's this idea of purposeful availment. We look to whether the defendant has reached out to the state. So, for example, in worldwide Volkswagen, there was not purposeful availment. One of the defendants, the car dealer, sold a car in New York, and that car ended up having problems and a fire that injured the plaintiffs. And it happened in the state of Oklahoma, was it?
Oklahoma.
Yeah, Oklahoma. Okay. Well, the court said is the defendant here didn't purposely avail itself of the state of Oklahoma. The defendant knew that a car is designed to travel around the country and could foresee the car would end up in Oklahoma, but who took that car to Oklahoma? It wasn't the dealer, right? It was the driver. The driver bought that car in New York and took it to the state of Oklahoma. The Supreme Court said we don't appoint the seller of an item, we don't appoint the item as the chattel for service of process. We don't appoint the chattel as the agent for service of process. This is very important. Purposeful availment requires the defendant itself has reached out to the forum state. Okay? Now, that is actually the core of the analysis in the first step. oftentimes students will say, well, they'll give me a purposeful availment analysis, and then they'll give a separate stream of commerce analysis or a separate Calder analysis, and that's just wrong. What the cases tell us is that in specific scenarios, there may be extra special ways of analyzing purposeful availment. So, for example, we have cases involving taxes. That's international shoe, the unemployment taxes. We have a case involving negligence. Hess, as the Supreme Court reinterprets Hess in the case of international shoe. We have several cases involving contracts, right? Burger King, and it doesn't say it up there, but also McGee, right? Burger King and McGee. Burger King tells us to look at a number of factors, such as the prior negotiations, the anticipated future consequences, the length of the contract, and so on, as factors indicating the extent of purposeful availment of a contact through an out-of-state contract. We have intentional torts, Calder and Walden. Now, Calder and Walden are extremely difficult. We didn't spend a lot of time on them in class, but think of Calder as looking to an intentional tort, such as defamation or remote intentional trademark infringement. The defendant knew the focus of the harm would be in the forum state, and the defendant's own conduct was aimed at the forum state. All right? That's how a lot of lower courts, an example of how a lower court interpreted Calder. In Walden, the Supreme Court further clarified the Calder test, telling us that in a Calder-like scenario, the fact that the plaintiff was injured in the forum state is not enough for there to be jurisdiction. And that kind of makes sense when you think about it, because purposeful availment looks at the defendant's contacts, not with the plaintiff's contacts. What the Supreme Court said in Walden is we need to look at the defendant's contacts with the forum state. So, the court, and I wrote this down from the opinion, does the defendant's conduct commit it to the forum state in a meaningful way? And there the plaintiff's injury in the forum state may be a consideration, but by itself is never going to be sufficient to satisfy personal jurisdiction. Beyond that, I'm not going to go into Calder and Walden. Internet jurisdiction we haven't talked about much in class, but I'll just note in passing, sometimes courts will analyze internet contacts by using the Calder or a Walden analysis, some sort of intentional act on the internet that causes injury and is focused at the forum state. Okay? Courts will oftentimes use the Zippo test, or some derivation of it, which looks to the commerciality and interactivity of a website. The more commercial and more interactive a website is, the easier it is to find purposeful availment. In contrast, the more passive and inactive the website is, the less commercial it is, the harder it is to find purposeful availment. I don't go to that much in class because I'm not so sure how helpful those cases are today in a day of apps, right? A day of social media, where you'll have something like Facebook, where the stuff that may piss somebody off on Facebook wasn't even posted by Facebook, right? It was posted by some third party. So this is an area of the law that's still developing that we can discuss outside of class, and I'm just noting it now in passing because I think it's interesting. All right. Finally, we have the stream of commerce scenario. Now, stream of commerce can involve a component or finished product that travels from its place of manufacture, the place of sale, through the stream of commerce. In other words, it goes through intermediaries. So manufacturer A makes the component or the finished product in one place, then A sells it or distributes it to B, then B might sell it to C, and then C sells it to D, and then it's purchased by the plaintiff in the forum state. And it doesn't require A, B, C, D, and E. It could be A to B, and then the plaintiff buys it in the forum state. The idea here is the defendant did not sell the product directly to the consumer. Rather, the product went through a distribution chain where it was purchased by a consumer and injured the plaintiff in that state. Well, what the Asahi split is about is how do you analyze purposeful availment in those kind of scenarios? And you have three different approaches. And I recommend, if you have a stream of commerce scenario, that you analyze purposeful availment regarding stream of commerce in this order. First, Brennan. Brennan's our bare stream of commerce theory. For him, as long as you have the, quote, regular and anticipated flow of products from manufacturer to distribution to retail sale, and the defendant is aware that the final product is being marketed in the form state, then there's going to be purposeful availment. So regular and anticipated flow of the products from the manufacturer to the point of sale, and the defendant is aware that the goods are being marketed in that state. For Brennan, that's enough. For Justice O'Connor, that's not enough. But what I want to make really clear is one of the elements of Justice O'Connor's approach is to incorporate Brennan's approach. For Brennan, Brennan's approach is necessary and sufficient. For O'Connor, Brennan's approach is necessary, but by itself, not sufficient. So what else needs to be shown for O'Connor's test to be satisfied? Well, those are the so-called plus factors. Additional conduct of the defendant. For example, advertising in the form state, channels for providing advice, marketing through a distributor who's the sales agent in the state, so on and so forth. Okay? So for O'Connor, you need Brennan's approach as the threshold, and additionally one or more of the plus factors. And I know the Supreme Court had the De Castro case decided a few years ago, but that court was split as well, and the law is still unsettled. Finally, Stevens has an approach that looks to a constitutional determination of the volume, value, and hazardous nature of the components. So volume, how many of them are sold? Value, how much are they worth? Hazardous nature, how valuable, or excuse me, how dangerous are these components? Or in the case of finished products, right? Finished products. Now, if you have a stream of commerce fact pattern, you need to analyze all three. And that means you've got to have three separate sub-analyses, each of which may involve argumentation and counter-argumentation. So be sure to structure it well. Also keep in mind that depending on the facts, you may reach a conclusion that is contingent upon which approach the court uses, right? And there was no majority regarding stream of commerce in Asahi. 4 votes including O'Connor, 4 votes including Brennan and Stevens. Okay, so you don't have a majority in Asahi. Off the top of my head, I believe Stevens had several people also joining him as well, but you just didn't have any majority on stream of commerce theory. Well, that's purposeful availment. That leaves giving rise and the reasonableness factors. The second step of jurisdiction under a specific jurisdiction is the contacts gave rise to the claim. Now, that means there's got to be sufficient connection between the contacts and the claim. There's actually 3 approaches the courts might use. In class, we mostly talk about the first 2. The evidence test asks, in proving the substantive merits of the claim, will the contacts themselves be evidence relevant to that claim? So you need to look at the contacts. You need to consider how the plaintiff would prove his or her own claim in court, the actual merits of, say, a negligence claim or a contracts claim. And will the contacts themselves be useful evidence in proving or disproving the claim? If the answer is yes, the contacts are evidence towards the claim, then the evidence test is satisfied. Well, some courts use the evidence test, some use the but-for test, which looks to the historical chain of events. But for the contact, there would have been no claim. In other words, if the contact never occurred, then the claim would never have happened, right? That's looking for a causal connection between the contacts and the claim. Think of the hypo we did in class involving the flyer from Alaska, right? But for the flyer being sent to Massachusetts, the defendant would never have gone to the forum state and suffered injury. But-for test. Other courts, please keep the noise down, guys. Please keep the noise down. Another test the courts might use is just look for some sort of relevant connection, right? There's some sufficient relationship between the contacts and the claim. So you might want to think about, even if but-for or evidence are not satisfied, what other arguments might you make that there's a connection between the contacts and the claim? Third step, reasonableness. So if there's purposeful availment, and if the contacts give rise to the claim, then the court, of course, wants to analyze reasonableness. Now, if purposeful availment is met, then the court will presume reasonableness, and the burden now shifts to the defendant to show a compelling case of unreasonableness. What that means is that once you have purposeful availment and giving rise, there's normally going to be jurisdiction, right? Unless it's really, really unreasonable to have jurisdiction. Like what happened in the Asahi case, right? Foreign manufacturer, the dispute was between two Asian companies regarding indemnification of a contract that arose in Asia. All right, the 5 factors. Burden on the defendant. Think about the burden on the defendant. Is it going to be difficult for the defendant to go to that state? Is it far away? Cost, distance, difficulty, things like that. The burden on the defendant. Second, the interest of the plaintiff. Why does the plaintiff want to get relief in this state as opposed to another state or a foreign country? For that, you can think about the fact pattern in the Amazon hypothetical, right? Where Peter Parker, the plaintiff, is suing in California, even though he could have sued in Delaware, Georgia, or Paris. Why California? Why is he interested specifically in California? Third factor, the interest of the forum state. Does the forum state itself have an interest in having this case adjudicated in that state? That interest may be arguably because one or more of the parties are from that state. It may be that the issues being litigated in that state concern matters of interest to the state, such as safety of products, safety of roads, things like that, right? Next, efficiency. Think of things like witnesses, parties, witnesses, joinder of additional parties, where evidence is located. Now, it may be that these people are spread all around. Well, is this particular state a good place for the litigation to be? Thinking about where the evidence is, where witnesses can be found, and so forth. Finally, the one the court that you struggle with, understandably so, and the one the courts almost hardly ever talk about, is the shared substantive interest of the states in substantive social policy. Okay? It's a mouthful. The shared interest of the states in substantive social policy. Think of this as not a matter of efficiency, but rather social policy. Do the various states of the United States share an interest in the subject matter of this suit regarding the subject matter, such as providing remedies in tort, right, or providing redress for contract violations? And if the case has international implications like Asahi, what about also the interest of other countries like France? Now, a last note about the reasonableness factors. Reasonableness factors oftentimes implicate argument and counter-argument. So in preparation for your exams, go back to the facts of the Amazon fact pattern and think about what arguments and counter-arguments you can make for each of those factors. A competent student will list all 5 factors and discuss all 5s. But what a good student will do is think about counter-arguments that can be made for all 5. And use your common sense there, right? Use the facts and your common sense to think of what arguments each side might make. Plaintiff will argue blah, blah. Defendant will argue blah, blah, and so on. All right. That sums up our review. I thank you guys very much for staying for the extended class. I hope this is helpful to you. I have office hours later today, and if I don't see you, thank you and have a wonderful weekend. Thank you.